Essentially, the city is unable to prohibit or have the effect of prohibiting the ability of any entity to provide personal wireless services or telecommunication services. But there is a general preservation of local authority to control the placement of wireless facilities subject to certain limits. Essentially, the Reader's Digest version is that the city has reasonable control, subject to certain limits, over the aesthetics of wireless facilities, the location and placement of where they can go, what they look like, in addition to other requirements as well that you could place. Section 253 reiterates the prohibition on prohibiting or having the effect of prohibiting an entity to provide telecommunication services. That term is slightly broader than personal wireless services. The next large change in telecommunications for wireless facilities was the adoption of the Middle Class Tax Relief Act of 2012. And Section 6409 of that act established what we now know today as eligible facilities requests. These are those modifications that, if the criteria are met, the city has no discretion and must approve. In addition, the FCC has also adopted a number of orders, declaratory rulings, and regulations that interpret the federal statutes and carry the force of law. Next, going to go through a few of those orders that are relevant here. In 2018, we had the moratoria ban order. Essentially, the city cannot place a ban or prohibition or any moratoria on new wireless facilities. This would also prohibit the city from adopting a cap or limit on the number of wireless facilities that can be deployed within the city. I get often jurisdictions will ask, can we just say 10 or 15, or how do we limit the number of facilities? Those caps would be prohibited by the moratoria ban. As I mentioned earlier, the city has to act in an expedited manner when reviewing wireless applications. This is a summary of the wireless shot clocks. They generally run from 60 days to 150 days. The shot clock starts the moment an applicant submits any of the required application materials. Even if their application is wholly incomplete, for shot clock purposes, the time period has already started to run. It's then incumbent upon the city to review the materials submitted and issue a notice of incompleteness to stop the shot clock. And if you can imagine, it's kind of like a game of speed chess where you're tapping on and off the clock with notice of incompleteness and resubmittals from the applicant until a decision is reached or within the FCC shot clock. If the city does not reach a final decision must also include any appeals or the issuance of any ancillary permits that are needed. If the city misses the shot clock, we now have deemed approved remedies through federal and state law that a applicant can avail themselves to. All that's needed to exercise a deemed approval, the applicant need only send a notice to the city that outlines that the shot clock has been missed and that their application is deemed approved. The applicant can then take that letter and use that as their permit and commence work as initially proposed. So a lot of the updates that we're going to be looking to make to the existing zoning code are going to be targeted to streamline the city's process and attempt to try to remove second and third level review for certain wireless facility types that have the shorter shot clocks. to try to avoid these deemed approved remedies. On RF emissions, the FCC has sole authority to set standards and regulations for RF emissions for wireless facilities. And so long as the applicant has demonstrated that a wireless facility would comply with the standards, the city cannot regulate the placement, construction, or modification of the facility on the basis of RF emissions. In addition, as I mentioned earlier, all decisions must be in writing and supported by substantial evidence. Direct or indirect concerns over the perceived health effects of RF emissions may not serve as substantial evidence to support the denial of an application where an applicant has demonstrated compliance with the FCC standards. Similarly, claims that a proposed wireless facility will result in diminished property values that are rooted in concern about the perceived effects of RF emissions cannot constitute substantial evidence supporting a denial of a wireless facility. Further, in recent case law has established that hypersensitivity to RF emissions does not require accommodation under the ADA. This is an argument we get every once in a while from anti-wireless groups. And so I wanted to include it here. Now, to discuss eligible facilities requests. These were adopted in 2012, and these are those modifications that if they qualify and meet the criteria set forth by the FCC, the city has no discretion and must approve. So these are any requests to modify an existing wireless facility that involve the addition of new transmission equipment, removal of new transmission equipment, or removal of transmission equipment, or replacement of transmission equipment. Eligible facilities requests are most often used by the wireless industry to upgrade and swap out equipment. They're also used to add new wireless tenants to an existing site. So for instance, if you have a wireless tower that has AT&T, for example, and their facilities on that tower, another wireless provider, say Verizon or T-Mobile or whomever, may utilize the eligible facilities request process to add their facilities onto an existing tower that would have been operated by AT&T in this example. Keep in mind that the modifications have to qualify and meet the criteria set in the FCC's regulations. But if they do, the city has no discretion and has to approve. Eligible facilities requests are a common area of dispute between local governments and the wireless industry. The FCC has stepped in on several occasions to further broaden the ability of wireless providers to take advantage of the eligible facilities request process. There was essentially a 3-year ramp-up period from the adoption of the Middle Class Tax and Relief Act to get the FCC's implementation order, which set forth the criteria I mentioned earlier. In 2020, we had 2 orders that were directly related to eligible facilities requests, and they have the net impact of broadening what would qualify as an eligible facilities request, thereby making it easier for the wireless industry to make upgrades, expand their facilities, and also add new facilities to an existing site. In the clarifications order, the FCC expanded what would qualify as an eligible facilities request by essentially shifting a number of the criteria to be a little more broad. In addition, they limited those types of concealment or aesthetic requirements that need to be carried through from existing conditions of approval through subsequent modifications as eligible facilities requests. So the FCC order limited those to only those type of concealment elements that need to be carried through to only those requirements that go towards ensuring the wireless facility is stealth, or as defined by the FCC, looks like something that does not appear to be a wireless facility. It's not the best definition, but that's the language that the FCC has used for establishing what type of stealth requirements need to be complied with through subsequent modifications to an existing site. So as one of our updates that we'd be looking towards is trying to craft those conditions of approval, those design standards that require the facilities to be stealth, and use that language from borrow that language from the FCC to ensure that any aesthetic requirements that the Planning Commission or the relevant review body at the city are carried through even with later modifications through the eligible facilities request process. Last, we have also in 2020 the expansions order. This order essentially shifted and expanded the area with which a wireless applicant can expand their existing area and excavate beyond the existing site. The prior criteria from the 2015 implementation order limited all eligible facilities requests to within the footprint of the existing site. The expansion order generally maintained that for most most facility types, but also broadened it to allow the addition of new cabinets and new ground-mounted equipment outside the existing site, among other smaller expansions over and broadening of what qualifies as an eligible facilities request. In 2018, the FCC adopted the small cell order. This is most applicable for wireless facilities that are deployed in the public rights of way, though there are still some small cell wireless facilities that are deployed outside the public right of way. But small cell technology in this order was largely adopted to facilitate the deployment of 5G technology in the public rights of way. So if you've ever seen a large, utility pole mounted facility or a streetlight facility mounted wireless facility, that meets like certain size limits, those are likely going to be small wireless facilities. Essentially, the FCC in its 2018 small cell order established this new type of wireless facilities that must meet certain criteria to qualify. They adopted a new effective prohibition standard. So essentially they developed a new legal standard for determining what city actions constitute the prohibition of personal wireless services. Originally, we had a significant gap test, which still applies for all the other wireless facility types. But at least for small cells, the FCC has adopted the materially inhibit standard, which, as we've seen over time, since the 2018 order was adopted, is much more friendly to the wireless industry, essentially making it easier for small cells to be deployed. The order also set forth new shot clocks, and most drastically different from all the other wireless facility types. This order also limited the fees and rents that can be charged by local jurisdictions for the use of the public rights of way, and even city-owned infrastructure in the right-of-way. It also limited fees to be cost-based and created safe harbor amounts. For instance, to give you an idea, prior to the 2018 order, the cities of San Francisco and Los Angeles would lease out streetlights to the wireless industry, and we're charging approximately $3,000 to $2,500 a month for use of those the vertical infrastructure in the public right-of-way. The FCC order limited that amount to $270 per year. So you'll notice that's a drastic decrease in the amount that local jurisdiction can charge for use of its vertical infrastructure in the public right-of-way for small wireless facilities. These amounts are safe harbors, so if the city is authorized to charge above the safe harbor amounts, but they typically need a fee study to establish those actual costs and in order to charge higher amounts. In addition, the small cell order also adopted some new standards that limit certain aesthetic requirements, among other items. In terms of aesthetics, the original 2018 small cell order required that if a city were to adopt aesthetic requirements for small wireless facilities, that they needed to be reasonable, no more burdensome than those applied to other types of infrastructure deployments. They needed to be objective and published in advance. This small cell, our firm represented the city of Portland and a coalition of other local governments from across the country in a suit against the FCC that was heard at the Ninth Circuit. The small cell order was partially upheld, but as part of that decision, the two requirements that you see marked out in red were removed from the order. So now the city's aesthetic requirements need only be reasonable and published in advance. A lot of local governments were having a very difficult time drafting objective design standards. If you've spent any time working with design standards, you can know how difficult of a task that is. And so this has actually freed up many local governments to be able to craft more expansive and a broader aesthetic requirements. Essentially, aesthetic requirements also must be technically feasible and reasonably directed as well in order to be permissible. Last but not least, state government has also gotten involved and to add additional regulations where not preempted. The state has adopted a number of deemed approved remedies for the FCC shot clocks. As I mentioned earlier, the one important note, it does come up every once in a while, is that the deemed approved remedy is not available under state law, is not available for any wireless facilities placed on fire department facilities. Wireless permits cannot be issued for less than 10 years unless there's public safety or land use reasons that are articulated for that permit. There's also limits on escrow deposits and other surety requirements that you can place on wireless permittees. You cannot require all facilities be located on site owned by particular parties. There was a brief period where certain jurisdictions thought that they could generate revenue by requiring that all the wireless facilities are placed on public property and thereby obtaining rent from the wireless facilities. State law has prohibited that action. You cannot require the facilities be located on sites owned by particular parties. And state law also recognizes federal authority over RF emissions in line with federal law. The one biggest update that we've had in the last year is the adoption of AB 965. This added a new section to the government code to addressing batched broadband permit processing. This has been in effect since January, and as of yet, it's been seldom used by applicants based in my interaction in working with a number of jurisdictions on wireless applications. App permit batching is already authorized for small wireless facility applications as part of the 2018 order, but this new state law essentially broadened that to allow broadband batch permitting for to include not only the authorizations for the wireless facility itself, but also any supporting fiber connections and related equipment. All the batched applications would be subject to one single permit, and the same FCC shot clock would apply for the entire batch. So the city is able to adopt a limit based on your population size. So for Avalon, that would be 25 within facilities in one batch. To qualify as a batch, they all need to be substantially similar in that they have substantially similar equipment, fiber connections, and design, but just in different locations. The difficulty here is that, let's say for Avalon, if you got a batch applications for 25 facilities at once, you would have to reach a final decision on all 25 sites under a single permit within that applicable FCC shot clock time. So if, for instance, if these were for small wireless facilities on existing structures, that would be 60 days from start to finish that the city would have to process all 25 under one single permit. So again, this is just to highlight that streamlining and accelerating the city's review process is one of the main goals we have with the update. Next, just want to give you a high-level overview of the city's existing wireless regulations and kind of give you a little more info on what we're targeting for an update. So there are two main areas of city requirements. We've got Title IV, which addresses wireless facilities in the public rights-of-way, and Title IX, which has a brief article on antennas. We are going to be targeting the Title IX article for an update. So as part of our review, we're also going to be taking a look at Title IV, just in terms of establishing if any updates are needed. This section or article was recently adopted in 2019 after the 2018 small cell order. So if there are any updates at all that are necessary, I would anticipate them to be fairly minor, since the largest update is that small cell order and these existing regulations for facilities in the public rights of way have already been adopted and updated. So for wireless facilities within the public right-of-way, they all would receive a wireless encroachment permit. They are administratively approved by Public Works Director, and an appeal can be made by any adversely affected person to the city manager. Article 9, as I mentioned, is what we're going to be mostly targeting for an update. This was last updated in 1997 after the adoption of the Telecommunications Act in 1996. As hopefully you recall from my brief presentation, there's been a number of updates since that time. And so what we're going to be looking to do is provide some updates and ensure compliance with these new regulations that have been adopted since 1996 and 1997. Essentially, as the code Article 10 reads now, there are certain processes for video programming antennas and satellite dishes and WIP transmitting antennas. There's no permit required for most satellite dishes that meet certain criteria. Generally, those criteria are fairly broad, and so most, I would imagine, would be have no permit requirement under this Article 10. If those satellite dishes or other programmed video antennas do not meet those requirements, site plan approval will be required and a height variance if needed. Similarly, WIP antennas are subject to administrative approval by the planning director. In terms of an update, these satellite dishes are known, at least treated as the FCC, as OTARDs, or over-the-air reception devices. And WIP transmitting antennas are most often used by amateur radio enthusiasts. The FCC has adopted a number of orders addressing satellite dishes or OTARDs and amateur radio that largely preempt the city's ability to place many regulations on these. Essentially, the city cannot place any requirements on OTARDs or amateur radio that are different or more difficult to satisfy than the city's typical process for adding appurtenances to an existing structure or wherever these facilities would be added. Then all other transmitting antennas, which would include pretty much any commercial wireless antenna used by any of the providers and carriers, those are subject to a conditional use permit plus site plan approval, and a variance is required if the height of the proposed facility exceeds any the development standards of the applicable code. I think generally, I think we're going to be looking to preserve the conditional use permit process for the longer FCC shot clock types, but attempt to move some commercial wireless facility types from a conditional use permit to a more administrative review process as part of our update. In addition, the existing Article 10 has very minimal standards for wireless facilities, particularly addressing design, aesthetics, location requirements or limitations, among other areas that we would try to supplement. And so those are areas that we try to add some more robust design standard and development standards for any new potential wireless facility. And with that, that concludes my presentation. So I've just discuss quite a number of items here, so I'm going to stop sharing my screen and take some questions. Stop sharing. There we go.
So Bennett, one thing, as far as all of these ordinance updates, do we have a timeline that we need to have these completed by, or is it because we've just waited so long, it's get it done as soon as reasonably possible?
There is no firm deadline. We're not up against a timeline in state and federal law. This is essentially an update since the code has not been addressed in quite some time. So this update is essentially to comply with all the changes to state and federal law since 1997.
And if we had an application in the meantime for one of these facilities where our code doesn't currently comply with standards, would we have to default essentially to a kind of more general process in compliance with state and federal law in the meantime?
So you would have to apply the requirements that are in the code at the time the application is submitted. Yes, the city would have to apply the existing regulations until an update has been adopted and it's effective. And so in interpreting and applying the city's code, there are certain areas that we would try or the city may not be able to enforce in that process. So this update would be targeted to removing those areas and ensuring that your process complies with state and federal law.
Great, thanks.
Sounds like the federal government telling you exactly what you have to do.
Well, not a complaint, but I'd like to know who their lobbyist was that put this together.
Because it's airtight.
Whoever that is, that's the firm you want to hire.
Yes, yeah, that is.
You know, let's put it together so it covers the carrier, absolutely, and then put one of the most worthless federal institutions in charge of the oversight. I like that.
Amazing. So in effect,
you, Bennett.
there's no city that could say, every person in this city says, I don't want this garbage in my city, and you could not, it would not hold up.
That's what I heard.
Right.
Yeah.
Yeah, that's correct. Yeah, the wireless regulations, particularly on the federal level, are certainly the product of substantial lobbying by the wireless industry. And as I hope it sounds like my presentation was successful in conveying that these rules are set up to enhance and the ability of the wireless industry to deploy facilities.
So what's interesting and what,
And to be fair, they've been spending billions of dollars making sure that all of us have these in our hands, so that, you know, I
well,
get it.
what is very concerning to me regarding this is in one, I can't think where my notes, where it says that the emissions, we have the right to regulate the emissions, and then in the next 2 pages later, it says doesn't matter about the emissions. So, I mean, we're 1 square mile. I mean, everything's together on the mainland also, but, so when they're saying they have to comply with the emission.
It's what they set forward.
Yeah, so it's what they set forward, and are they the ones that regulate that, or can the city come in and have a third party test emissions? Cause we're just gonna say that that's what they said, it's fine, and then we just have, it looks like it doesn't matter what we say, what we gathered after this whole presentation, but it's kind of scary, actually.
Yeah, so in terms of RF emission compliance, the FCC has broadly preempted local control or any supplemental requirements. Essentially, an applicant just needs to provide a certification, usually through an RF report signed by an engineer, a licensed engineer, that outlines that the facility, as proposed, would comply with the FCC standards. The city can ensure that the facility does comply with those standards. You have no obligation to approve a wireless facility that does not comply with the FCC standards for RF emissions. But there are limitations on what the city can do. As your example stated earlier, that the city could conduct its own independent evaluation or field study of RF emissions of a new facility or an existing facility. But there are some case law that has established that the city cannot require in field testing for wireless facilities by the applicant. So that would be something that the city would have to do at its own cost. In addition, the city cannot require the applicant to conduct fields testing, and only modeling is sufficient enough to establish by the applicant that the proposed facility or modifications to an existing facility will comply with the FCC standards. So it's a little tricky area of the law in trying to work with RF emissions. I know, having done a number of updates and assisted local governments in reviewing applications for these and appeals of decisions, there is an area of the public that are concerned about RF emissions. And, from the electeds and the commission's standpoint, and in line with federal law, so long as the applicant has demonstrated compliance, there's really nothing that the city can do to deny that application based on concerns over RF emissions.
Thank you.
Big government gone mad. Thank you, Bennett.
Thanks, Bennett.
Yeah, no, of course. Feel free to, if you have any questions as you're thinking through the materials, feel free to reach out through staff, and I'd be happy to answer them one by one or as they come through. Again, we are preparing a draft with staff. We're still in the initial stages of that draft. And I would, once we have finalized that draft, we would bring it to Planning Commission for your review and recommendation.
Thank you.
Thank you. Thank you.
Any other commissioner business? Say goodnight to Tony.
Good night, Tony.
Good night, Tony.
Good night, Tony. Adjourned.
Thank you.
Wow.